All right, let's get started. I'm Adam Bloomberg, Senior Client Success Advisor at IMS. Today's conversation is with Keely Duke of Duke Evett in Boise, Idaho. She's a veteran trial lawyer who has spent her career defending high-stakes matters in the Pacific Northwest and the Ninth Circuit Court of Appeals. The conversation will be led by Chris Dominic, Senior Strategy and Jury Consulting Advisor here at IMS. They will explore how she approaches cases where the odds are challenging, how she prepares executives and witnesses to testify with authenticity, and why credibility remains the cornerstone of persuasive advocacy in front of the jury. If you're watching the recording of this broadcast, please like and subscribe to this channel. Chris, it's all yours.
Welcome, Keely. How you doing?
I'm doing great. How about you?
Good. I really enjoyed our conversations recently, and it warmed me up for this. I'm really excited to ask you some of these questions.
Well, ditto.
All right. Well, you've built your practice around defending high-stakes clients in complex litigation, right? What's the first question you ask when you walk into a case where things are already kind of stacked against the client?
I'm asking, what do you want out of this? And honestly, I'm doing that whether it's stacked against the client or it's not. It is, what do you want to have happen? Do you need to fight this to the death? Do you want to get it resolved, even though you have the best case in the world? You have severe issues with the case. I'm here to say, what do you want to see happen with this case? Why are you hiring me? And then I'm going to tell you, can we get it done?
Okay. So you're thinking almost in like a reverse engineer way.
Correct.
Okay. Tell me what the end state is. Then I can work backwards from that.
And I'll let you know how practical it is to create this result that you want.
Yeah, that makes a lot of sense. Okay, so you and I have been talking a lot about credibility as one of the three pillars of persuasion, right? And how it seems that it's become kind of a lost art with some. When you're preparing a company executive, which I know you've done a lot of, to testify in a sensitive or technical case, what's the biggest credibility trap that you advise them to avoid?
They cannot come across as haughty or over-intellectual. They have got to come across as a real person with real feelings, real concern, real care. And if they don't, the jury is going to ignore them.
Mm-hmm.
And actually dislike them.
Well, that's a real thing.
Yeah.
It's funny you say that because we've been often talking about, we use these constructs of credibility we've been using for decades, but we end up talking a lot about the way jurors react to people when we show them depo clips of them. Or one of the things that we'll hear from people is they'll talk about people being real or being authentic. Mm-hmm. And there seems to be a real premium on that these days, right?
Absolutely. And they just don't want, jurors don't want to just see that from the witnesses. They want to see that from the lawyers. That makes all the difference in the world. And I'll tell you, the great majority of trials, I can think of times where my opposing attorney was my best asset because they overpromised, they weren't credible. And then when we can capitalize on that through the case, the jury gets it. They have common sense.
That makes so much sense. Lately, we've been studying the trade-off between advocacy and credibility, because I think sometimes that's why that happens, right? It's like, I should argue this without thinking about the fact that it might not land and it might hurt your credibility. So sometimes clients often want to push every argument they think they can push, right? How do you guide them toward the few themes that move jurors? Or it doesn't have to be themes, right? Anything that helps instead of pushing something that people might not believe on its face.
Well, I think there's been a huge shift. So to get a little philosophical on you, I think there's been a huge shift over the last few years of logic and, great explanations. The evidence is all stacked in your favor, and that's great. However, if you don't have a really compelling theme, if you're not really advancing your side of the case versus defending the case, you're not biting into the traps that the plaintiffs leave you, I really think you're doing a disservice to your client. Jurors want to feel good about their decision. And so even if you have all the evidence in the world, and it's important to have that, but you've got to come up with your key themes where you can sell it.
Right.
through everything.
It's interesting you say that, because sometimes what we'll talk about is, let's not defend this. Let's have our own case. Let's have our own narrative. Let's be activating our own human values in this narrative. And let's give them a psychologically satisfying defense verdict, right? Or at least a good verdict.
Correct.
Whatever it is. Yeah, that's a difficult thing to accomplish sometimes, because if you're not in the habit of doing it, you have to really deliberately do that work. Do you find it's hard to convince people of doing that work sometimes?
It can be, but actually with good prep, which is crucial to any of this, is you've got to prepare your witnesses well. You need help from professionals to do it, like you all, and you've got to practice. And when you do that, you're going to come up with your themes that are going to resonate with you, and some are not. Some are you're going to think they're great, and then you're going to hear them out loud, and you're going to go, I don't love that, but let's shift it this way. And you're doing that throughout your depositions. You're even doing it with your briefing to the judge, because you're not only selling, a good feeling to the jury, you're selling it to the judge.
Absolutely.
Judges, we want them following the law, but they really like following the law when they feel good about it.
It's interesting you say that, because speaker credibility really is the lawyer speaking. It's witnesses speaking. We can't really find a big distinction on that.
Mm-hmm.
And I think one of the reasons why it's stressful for people sometimes, and why they don't practice the way they should, is because it's public speaking. A lot of people are scared of it, even lawyers sometimes. So is there anything you can do to encourage people to focus on that part of their craft, if you will? Because it's something I often have to encourage, and I'd love to get any tips I can from you.
Practice makes perfect, in my view. And I mean, there's even times we'll have our witnesses, we'll bring in people on our own to sit there, 15, 20 people, and have our client go through an examination, so that they're having to speak in front of people. With our younger lawyers, we'll have them get up, and we'll have them present arguments and cases and ask them questions to start getting them feeling comfortable being on your feet, because it's a lot harder than it looks.
Yeah, it really is.
Yeah.
And it's often humbling when you look at a recording of yourself, right? People always tell me when I work with them, I hate the sound of my own voice, or I hate the way I look on video. And I think that's what is the discouraging factor sometimes. But as you and I were talking recently, I don't know how you get better at dancing without dancing, and I don't know how you get better at golf without swinging the club. And
you don't, in my view.
Right.
We're not all just built to just stand up and do it perfectly. It takes practice, and even the best of the best. And I feel that I fall into that category. I'm practicing. I'm making sure that when I hit the ground, I'm hitting it running.
Yeah, absolutely. It makes so much sense. Okay. So I'm just staying with credibility for a little bit. You've earned a reputation for fighting hard, but not losing your credibility. How do you balance tenacity with the right kind of restraint, so the jury goes and sees strength, not aggression?
So two answers to that question. First, it starts with the client. I am not going to tell the client what they want to hear. They're not paying me to tell them what they want to hear. And if they are, I'm the wrong attorney, because like I said at the beginning, I'm going to work my way backwards. What is your goal? And from that, let's see where we can go. And the goal may shift throughout because of what we find or whatnot. But I am not going to tell my client what they want to hear. I'm going to be straight up. They're going to hear the good, the bad, and the ugly is what I call it. And then we go from there. With a jury, you cannot oversell to a jury ever. And if it's even the slightest edge that you give your opponent by overstating something really simple, or just having a skew on something that isn't quite there, if they're really good, they're going to just absolutely beat you over the head with it. And then you're going to lose credibility ounce by ounce. And those ounces add up by the time the jury's back there deliberating.
So they might be doing this because they think, I'm just being a zealous advocate. The problem is you can't be a zealous advocate if you're losing your credibility.
Correct. Yeah. It's impossible to be. I mean, you've got to, your number one goal is to maintain your credibility in front of that jury. And then from there, advocate for the basic themes and facts that you have, so they're hearing them over and over, and they know that when you say something, you mean it.
Yeah.
I'll even go as far, I do a lot of defense work, as you know, and in the corporate world, you're on one side or the other. But when I'm on the defense, they always get the last word in closing. And I think it's a huge error for a lawyer to not look at that jury, because you've gained that credibility at that point. And right before you sit down in your closing, say, listen, I don't get to get up here again, but guess what? So-and-so does. And I need you to be me for the next 2 minutes, 5 minutes, 30 minutes, however long they decide to go, knowing I don't get to come back up and rebut what they're saying. So I want you to think of everything that you've heard evidence-wise, and don't be fooled.
I love it. Thank you, Keely. I've got one more question for you. If you had to give advice to somebody really new in their career who wants to be a first chair litigator, trial attorney, plaintiff side, defense side, anyway, is there any big picture advice you could give them?
Know your case and facts like the back of your hand. And from there, be true to who you are, because no one can emulate anyone else's style. We all have our own styles. And connected to that is you've got to realize that people don't want to just hear what they want to hear. It's your job to be an attorney and a counselor at law. And I take the counselor at law piece incredibly seriously.
I love it. Thank you.
Thank you.
Adam, it's all yours.
Thank you to our guests for speaking with us today. To discover how the IMS team can help give your case an edge, check out imslegal.com or shoot us an email at contactus@imslegal.com. IMS has served trusted law firms and corporations worldwide for more than 30 years and over 65,000 cases. As a strategic partner for the full case lifecycle, our integrated teams provide specialized advisory support, expert witness services, litigation consulting, visual advocacy, and presentation technology to elevate strategies and protect hard-earned reputations. Learn more at imslegal.com.